Antitrust, Competition Policy, and Consumer Rights. Today we're pleased to have with us the Chairman of the Federal Trade Commission, Joseph Simons, and the Assistant Attorney General for the Antitrust Division of the Department of Justice, Makan Delrahim. Welcome to both of you. As an initial matter, as a matter of housekeeping, we've been informed that we may have a block of 4 votes starting about an hour from now. As a practical matter, we may well be able to push it to an hour and 15, hour and a half from now before we have to recess. At some point, we likely will have to go recess to cast a few votes. We will have to play some of that by ear. I apologize in advance for that. There's no way to predict these things in advance. It does seem, however, to be an uncanny event with antitrust subcommittee hearings. It seems to be a good predictor, albeit an unintentional predictor, of when votes are going to occur. As both of you know, I've been critical of the fact that we have 2 federal agencies responsible for civil antitrust enforcement. And this, of course, is not your choice. This is a choice made by Congress in years past. And so the fact that the law is the way it is has a lot to do with this branch of government and not to do with your respective offices. And I have to say, your 2 agencies have done a remarkable job in recent points, in recent months, of making the points that I have with regard to my concerns about having 2 agencies with overlapping civil antitrust enforcement authority. Yes, it's true that for many decades, the FTC and the Antitrust Division of the Department of Justice have jointly handled civil antitrust enforcement. But in the past, the agencies have avoided too much mischief because they've generally played well together. And recently, this appears quite regrettably to have changed. From what I hear, from what I can tell, clearance disputes have become more frequent, more pronounced, and more prolonged. It's bad enough that your agencies sometimes determine who will investigate a matter according to possession arrows and coin tosses. But these clearance disputes impose real costs by wasting resources, creating delays, and creating a certain amount of institutional pettiness. Having 2 federal agencies handling civil antitrust enforcement is also creating confusion, both here and abroad, when the FTC and the DOJ are not on the same page. This is clearly on display in the recent Qualcomm matter, where your agencies are literally opposing each other in federal court. None of this makes for effective or efficient antitrust enforcement. Not one of us would design a system from the outset if we were writing on a blank slate this way. Earlier this summer, we learned that your agencies have begun investigating the large tech firms, some large tech firms, to see if they've violated antitrust laws. And I've said before, I'm encouraged that the FTC and the DOJ are bringing much-needed antitrust scrutiny to these tech companies. But I'm also concerned about the way you've divvied up these investigations. Now, I understand when it comes to specific investigations, your clearance process designates a single agency to investigate a specific matter. But based on news reports, it sounds like your agencies may be pursuing monopolization investigations of the same companies at the same time through 2 different agencies. Now, let me be clear. I don't think your agencies should be divvying up parts of a monopolization investigation of the same company, tech company or otherwise. Former FTC Chairman Bill Kovacic has called this nuts, and I agree. There's no analytical basis for splitting a monopolization investigation between the FTC and the Department of Justice. Doing so simply looks like both agencies simply want to have not just a slice of the same pie, but the same slice of the same pie at the same time. This will have the agencies stumbling over each other and will inevitably undermine rather than further the enforcement efforts of both agencies. Consumers, of course, deserve better than that. Consumers are harmed when you're tripping over each other and you're unable to do your job effectively. On the topic of big tech, I'd like to hear your views today on whether viewpoint bias should be the subject of antitrust enforcement. I share many of my colleagues' concerns with what appears to be bias against certain political viewpoints, particularly conservative political viewpoints by companies like Google and like Facebook. What I don't necessarily share is the suggestion by some that antitrust is necessarily the proper tool to address this issue. But I'd welcome your thoughts on this topic, as I certainly have more to learn. We often hear talk that antitrust policy needs to evolve to address competitive issues in these tech markets. Advocates of the so-called hipster antitrust theory argue that antitrust is too focused on price effects. They claim that this causes antitrust enforcers to ignore anti-competitive conduct in markets where consumers receive services for free. I'd love to know your thoughts on that topic. Finally, I hope we'll have time to discuss what the Antitrust Division is doing when it comes to music. This includes what the division is considering in its review of the music licensing consent decrees. Also, and I know this is something that my Democratic colleagues have raised with you, I'd like to hear more about what the Department of Justice is doing to police anti-competitive conduct in the ticketing market. Senator Klobuchar will now give her opening statement.
Thank you very much, Mr. Chairman. Good afternoon to Chairman Simons as well as to Assistant Attorney General Delrahim. We're pleased to have you both here to discuss this very important issue. These times are far from typical for antitrust and competition policy. Many new antitrust issues have arisen since our last oversight hearing. The American people increasingly understand that competition is critical for their well-being. They know how important it is for consumers, the health of our markets, and the future of our economy. And that is one thing that I've noticed as a change over the last year, is there's just more and more discussion about the need to do something about enforcement in this area. Yet despite this widespread recognition of how important competition is to our nation's future, we still as a country have a major monopoly problem. Given the grave competition problems we are facing, while as much as I appreciate my colleague's focus on the two agencies and what he referred to as mischief, I am much more concerned about the bigger picture, which is how we're going to take on the monopoly issues of our time and how we're going to take on the competition issues, whether they are in tech or whether they are in the pharmaceutical area or so many others. And I was thinking about the analogy of splitting the pie. I am more concerned that our consumers are going to get a big pie in their face if we don't do something about this. We are seeing higher levels of market concentration across our economy, partially driven by waves of corporate consolidation. Since 2008, American firms have engaged in more than $10 trillion in acquisitions, and between 2012 and 2017, annual merger filings at the antitrust agencies have increased by more than 50%. And those waiting for this trend to slow down will need to wait longer, because the latest agency report shows that merger filing increased yet again in 2018, the sixth consecutive annual increase. These more concentrated markets have led to decreased competition in many industries, including pharmaceuticals, social media, digital technology, telecom, ag, online, ticket sales, transportation, and more. Today, I sent a letter to the FTC with a number of my colleagues raising concerns about two proposed pharmaceutical mega mergers. That would be AbbVie's acquisition of Allergan and Bristol-Myers' acquisition of Celgene, and their potential effects on prices. There's one additional matter I will be raising at this hearing. Since the beginning of this administration, I have repeatedly had cause to raise concerns about reported White House attempts to interfere in antitrust enforcement efforts for political purposes. I've sent numerous letters to the Department and the White House concerning potential interference in antitrust law based on statements that the President and administration officials reportedly made regarding matters such as the Bayer-Monsanto merger, the AT&T-Time Warner merger, and the still pending T-Mobile-Sprint merger. Not all of my letters were answered, but the responses that I did get contained carefully worded assurances that the department had followed its procedures and that it was, quote, not aware of any influence by the White House, end quote, on any of the antitrust matters in question. The actual extent of any contact between the White House officials and the department enforcers concerning pending antitrust matters is still a mystery. And now we have reports of the Antitrust Division investigating 4 automakers for negotiating with California regulators to lower California fuel emission standards to a level that would be more stringent than the standard that the Trump administration intends to impose. The automakers' reported conduct seems to be little more than an effort by regulated companies to petition a state regulator for more favorable rules, something that happens all the time between state and federal regulators. Quite frankly, the antitrust investigation into these automakers appears to have less to do with protecting competition than with intimidating parties that don't fall into line with the Trump administration's plan to relax emission standards. A letter from the EPA and the Department of Transportation to the California Air Resources Board only bolsters the perception that this antitrust investigation is part of a broader effort by the administration to promote its preferred emissions standard and bully those who get in the way. For years, both antitrust agencies have talked about applying the consumer welfare standard. This investigation looks more like enforcement guided by a corporate welfare standard for oil companies and light truck manufacturers. I have questions about how this investigation regarding the gas mileage standards was initiated and why the division decided to use its limited resources to pursue it. As a matter of prosecutorial discretion, I find it hard to believe that an investigation into 4 automakers trying to navigate a shifting regulatory landscape is the best way to protect competition and consumers when we're seeing consolidation in so many industries. Sometimes why you do something is as important as what you do. Also, the antitrust issues that have been received the most attention, of course, are those raised by the major tech companies. We are living in a time of rapid technological change. These changes have led to the rise of powerful technology companies that have come to dominate markets and gather massive amounts of information from consumers, raising serious concerns about competition and privacy. At our last oversight hearing, I questioned why European enforcers have been investigating big tech for years while our agencies were doing nothing. Since then, not only have we heard reports about tech antitrust investigations by the FTC and Antitrust Division, but also by many state attorneys general. But these new enforcement efforts, of course, occur against a backdrop of a federal judiciary that has become increasingly skeptical of antitrust enforcement, raising the procedural and evidentiary bar for government and private enforcement. And some have questioned whether the antitrust laws are up to task. I question that very much, and that is why I have these bills that I think would be so helpful. One, I appreciate the work Senator Grassley did with me on the Merger Filing Fee Modernization Act that we introduced that would help with funding for both of your agencies. And then also, I've introduced the Consolidation Prevention and Competition Promotion Act with my colleagues to upgrade the antitrust standards to get at some of these issues that we're going to be hearing about today. And then also, of course, the civil fines for monopolization bill, as well as the prescription drug pricing bills, one of which I have with Senator Grassley. In closing, as a former prosecutor, I know how important it is to have enforcers that are ready and able to enforce the law without fear or favor. You both have the responsibility to ensure that your agencies act as vigorous yet impartial law enforcers. Millions of Americans and the health of our free market depend on your efforts and your judgment to ensure that the economy remains fair and competitive. Thank you, and I look forward to your testimony.
Thank you, Senator Klobuchar. We'll now be pleased to hear from both of our witnesses, each in turn, for their opening statements before we proceed to questions. Joseph Simons was sworn in as the chairman of the Federal Trade Commission on May 1st, 2018. Earlier in his career, he had served as the director of the FTC's Bureau of Competition. Makan Delrahim was confirmed on September 17, 2017 as Assistant Attorney General for the Antitrust Division in the Department of Justice. Mr. Delrahim also worked at the Antitrust Division earlier in his career, having previously served as Deputy Assistant Attorney General. No stranger to the Senate, Mr. Delrahim knows his way around this institution, having previously served as Chief Counsel to the Senate Judiciary Committee. Mr. Simons, we'll hear first from you.
Thank you so much, Chairman Lee, Ranking Member Klobuchar, and members of the subcommittee. Thank you for the opportunity to appear before you today. I am pleased to testify on behalf of the FTC regarding our current competition enforcement activities and policy priorities, and of course also to be alongside my esteemed colleague, Makan Delrahim. The FTC's mission works to ensure that our nation's markets are competitive and working for American consumers. We do this through targeted yet vigorous enforcement of the antitrust and consumer protection laws, and also by using our unique research and policy tools. Today I will focus my remarks on the antitrust side of our mission. We promote competition through a rigorous, fact-intensive approach to law enforcement. We have jurisdiction over a wide swath of the economy and focus our enforcement efforts on sectors that most directly affect consumers and their wallets, such as healthcare, pharmaceuticals, consumer products and services, technology, manufacturing, and energy. In fiscal year 2019, the agency has challenged 20 mergers so far. In June, the Eighth Circuit upheld our request for an injunction blocking an anti-competitive merger among healthcare providers in North Dakota. This case is our fifth straight appellate victory involving healthcare consolidations, following successful appeals of hospital mergers in the 3rd, 6th, 7th, and 9th circuits. This string of appellate victories across multiple circuits has solidified our analytical approach to these mergers. The current state of the law relating to hospital mergers is no accident. It reflects the culmination of efforts to use the agency's enforcement, research, and policy tools to protect healthcare consumers. In the 1990s, the antitrust agencies lost a significant number of consecutive court challenges to hospital mergers. In response, the FTC launched a merger retrospective study that questioned the prevailing economic methodology that courts had relied on in ruling against the agencies in these cases. Those results, in turn, influenced our subsequent enforcement work. Through our unique research capabilities, we successfully moved courts to embrace a modern economic approach to analyzing competitive effects in these transactions. On the conduct side, in 2019, we filed a complaint against SureScripts for using vertical restraints to monopolize 2 markets associated with electronically transmitted prescription information, and we have 2 other monopolization cases on appeal. The agency has been consistently active in this area, bringing 24 monopolization cases since the year 2000, including several while I was the Bureau Director. In 2013, the Commission won a critical victory in FTC versus activists when the Supreme Court clarified that pay-for-delay arrangements can violate the antitrust laws. This long-running case finally concluded this year on the eve of trial when the defendants agreed to settle. In March, the Commission held in an administrative proceeding that Impacts Laboratories and Endo Pharmaceuticals had entered into a reverse payment arrangement that delayed generic entry of an extended-release opioid used for pain relief, Opana ER. The agency continues to monitor the use of anti-competitive reverse payment settlements. I would also like to highlight our work in the technology sector. Our Bureau of Competition recently shifted resources to establish a dedicated technology task force. This task force is up and running and is actively investigating competitive activity in the U.S. technology markets. For example, we are currently pursuing an antitrust investigation of Facebook. In addition to targeted law enforcement, we also have a robust research and policy function. We are in the process of concluding our hearings on competition and consumer protection in the 21st century. We convened 14 sessions over 23 days with thousands of people attending in person or watching via live webcast. We are distilling the large volume of stakeholder information and generating output, which likely will include reports, statements, guidance, and speeches. The FTC remains committed to marshaling its resources efficiently in order to protect consumers and to promote competition, to anticipate and respond to changes in the marketplace, and to meet the current and future challenges. We look forward to continuing to work with this subcommittee and Congress, and I look forward to your questions. Thank you.
Thank you, Chairman Simons. Mr. Delrahim.
Thank you, Chairman Lee. Thank you, Ranking Member Klobuchar, former Chairman of the committee, Grassley, and I see former Chairman Leahy has left, and distinguished members of this committee. Thank you for having me before you today, and I also appreciate being next to my colleague, Chairman Simons. Chairman Simons and I go back over 20 years. We were both on the same side, I think, on the consumers in the past investigations of Microsoft from representing different parties. But our work has continued, and I'm pleased to work with them now across the street. The importance of antitrust enforcement continues to occupy the front pages these days, in large part to the efforts of many on this subcommittee. I want to thank the subcommittee for continuing the bipartisan support of the Antitrust Division's work to protect competition on behalf of American consumers, workers, and entrepreneurs. When corporations or individuals fix prices, rig bids, or allocate the markets, they're robbing Americans of honest competition. The Antitrust Division has steadfastly held culpable the culpable actors accountable. Numbers can only tell part of the story, but I'm proud that at the close of fiscal year 2018, our criminal program had the highest number of pending grand jury investigations, 91, over the past decade. I'm particularly proud of the guilty pleas we obtained from 5 South Korean fuel companies that rigged bids on Department of Defense fuel supply contracts at the expense of the American taxpayer. The crimes in these cases directly targeted taxpayer dollars which fund the critical work of the U.S. military in the Korean Peninsula. We obtained criminal and civil penalties in these cases amounting to over $350 million. In civil enforcement, the Antitrust Division continues to confront multi-billion-dollar mergers that involve industries important to every consumer, ranging from media to healthcare to transportation and telephony. Even with our constrained resources, the Antitrust Division has not hesitated to litigate when we have needed to, after we have found a merger to be anti-competitive. Separate from and as a complement to our enforcement mission, the Antitrust Division has engaged in robust competition advocacy, implementing a wide range of initiatives designed to advance competition. For example, the division has used its amicus initiative to address developments in case law earlier and more frequently, providing the opportunity to have an outsized impact given our resources. For instance, the division recently filed a statement of interest and argued at a hearing in a private antitrust case. The suit alleged that 2 major universities entered into an unlawful agreement not to poach each other's medical school faculty. We were able to advance important arguments before the court about the application of the per se rule of antitrust law, and also push back on overly broad assertions of antitrust immunities in that case. Subsequently, and I think in an innovative manner, we successfully intervened in the settlement of the parties. After we had successfully argued in that case, the parties decided to settle. We intervened, the court accepted our motion, and doing so enabled the Antitrust Division to obtain the same relief and protections for the American worker that we would have achieved had we conducted our own lengthy investigation. It also provided some transparency to the markets about our enforcement priorities with respect to no-poach arrangements. The division has also held workshops and roundtables, including a discussion of the Antitrust Criminal Penalty Enhancement and Reform Act, which is up for reauthorization in less than a year. I'm pleased that the administration has a position to seek reauthorization of that legislation. In addition, we've held a workshop on media advertising to inform our efforts to apply long-held antitrust principles to the continuing evolving digital advertising market. As I testified before the subcommittee last fall, the division has recently established the Jackson Nash Address. This lecture series is designed to inspire and educate division staff and the public about cutting-edge issues and developments in the field of economics. Thus far, we've been honored to hear addresses from Nobel Prize-winning economists, Professors Alvin Roth, George Akerlof, Roger Myerson, and last year's Nobel Prize winner, Professor Paul Romer. Each have provided valuable insights into innovation, competition, and possible threats facing the modern economy. Internationally, the United States, its businesses and consumers benefit when other nations enforce their competition laws according to sound economic principles and in accordance with appropriate procedures and protections. You may recall that at my confirmation hearing before this committee over 2 years ago, I identified this issue as a top priority for me at the division. I'm proud to report that our initiative for a multilateral agreement and our efforts over the last year led to the International Competition Network's framework on competition agency procedures. This is an historic achievement for procedural fairness in antitrust enforcement across the globe, with now over 70 signatories. Many doubted that this administration would be able to achieve this. I'm also proud to share that the United States sought and is granted the privilege of hosting for the first time the ICN's annual conference in 2020. We will jointly be hosting that with the Federal Trade Commission in Los Angeles. This is the most important conference for global competition enforcing agencies. Our host status will allow the division, along with the FTC, to showcase our ideals by promoting fundamental due process through the CAP. We also will be able to engage with the world on a range of other important policy issues, including digital platform competition, cartel enforcement, and cross-border merger cooperation. It's been nearly 2 years since the Senate confirmed me to this post. Each day presents new challenges, but there are two constants. First is the pride and responsibility that I feel as I work with the talented attorneys, economists, and staff of the Antitrust Division. And second is my unwavering belief that the work we do at the Antitrust Division continues to provide for a competitive American workplace that benefits all Americans. Thank you.
Thank you very much to both of you. We'll now begin 5-minute questioning rounds. In response to my first 3 questions, I'd like a simple yes or no answer from both of you. We'll start with Mr. Simons and then go to Mr. Delrahim for each of these 3 questions. Mr. Simons, do you believe that your agency could benefit from more resources to enforce the antitrust laws?
Yes.
Mr. Delrahim?
Yes.
Would it be a waste of resources, those that you have within your agency, for your agency to be investigating the same conduct in the same company at the same time as something that's already being investigated by the Department of Justice?
Yes.
Mr. Delrahim, likewise with respect to the FTC. Mr. Simons, are you aware of any instance, any matter prior to 2019 in which your 2 agencies were investigating the same company for the same conduct at the same time?
No, Senator.
Mr. Delrahim?
I don't recall. No.
Okay, thank you. Let's move on to clearance. Back in June, news reports suggested that your agencies had divvied up review of the dominant tech firms. But in July, the Justice Department announced that it is conducting a broad review of the leading online platforms. It sounds to me, in context, like your 2 agencies are covering the same ground, at least in very significant part. In fact, the Wall Street Journal reported yesterday that the Justice Department may conduct its own antitrust monopolization-related investigation of Facebook, despite the fact that the FTC is already investigating Facebook under a monopolization theory. Chairman Simons, are the FTC and the Department of Justice still operating under a clearance system to avoid duplicative efforts, or have things broken down on this front?
For the vast majority of matters, we continue to operate under the existing clearance agreement.
I'll take that as a yes. Things have broken down, at least in part. I would agree with that. Mr. Delrahim, what can you tell us about that? Have they broken down, or are you still using it? Do you agree with Mr. Simons' suggestion?
Well, the clearance process and the agreement is a process we are continuing to use.
But you'd acknowledge that it's broken down in at least some cases?
I would acknowledge that there's, over the last 20 years, and you might recall that Chairman Muris and Assistant Attorney General James, when they faced this back in 2002, I believe, entered into an arrangement that could have solved a lot of the problems, because this has been going on not recently but in the past. The Senate Appropriations Committee put a provision in preventing the agencies from implementing that orderly agreement. But it was one of the 2 agencies that resolved, and it might have prevented some of these problems. But I cannot deny that there are instances where Chairman Simons and my time is wasted on those types of squabbles.
Thank you for your candor on that point. As I mentioned in my opening statement, I don't think there is a sound basis. I don't think one can conceive of a sound basis for splitting up a monopolization investigation between your two agencies. Any monopolization investigation must look at the totality of the company's efforts in attaining or in maintaining monopoly power. That cannot be done piecemeal. It doesn't work. It's something that doesn't exist in the abstract and certainly isn't going to work in practice. Mr. Delrahim, have the Department of Justice and the FTC ever split a monopoly investigation between themselves before?
I'm not sure if there was.
You can't think of any?
I can't, and certainly not in the last 2 years that I discussed. But I want to clarify one thing. It's not so much the monopolization cases because, frankly, most of the antitrust laws of Section 1 and 2 of the Sherman Act, maybe a Section 8 of the Clayton Act, and outside of merger, Section 7. But we would look at different conduct, perhaps, of the same companies, and that might be what we might be talking about here.
Okay, so you might have one agency more interested in one piece of conduct than the other, but by your own acknowledgement, both of these are monopolization-based investigations. Those cannot be done piecemeal. Mr. Chairman Simons, the FTC and the Department of Justice are, in fact, structured differently. They have different policies, different procedures, in addition to having different personnel. In most cases, they're bound by the same substantive provisions of antitrust law, but the FTC also has some authority to act under a separate set of laws dealing with unfair methods of competition. Is it even feasible for your two agencies to split between yourselves what is, in effect, a single investigation when it comes to monopolization?
Well, it's not the normal thing to do, that's for sure, and we haven't done it in my recollection, and I've been practicing for about 35 years now. But it's also the case that we cooperate regularly with the state attorneys general on the same exact case, not even dividing it up.
Different standards of substantive law.
Usually, in many cases, they're applying the same standard, and sometimes it's helpful because they in particular have more expertise in local areas. So sometimes, particularly like, for example, on mergers involving gas stations, they know the terrain, they know what the local markets look like.
It is, in fact, a different sovereign, though. You're dealing with
it is a different sovereign. That's absolutely.
You two are agencies.
And let me just say, ideally, you really do just want one agency from the federal government doing it, if for no other reason, because the resources that one of us is duplicating on the other could be applied to a completely different enforcement action or investigation.
Right, and as you've both acknowledged, both of you could use and desperately need more resources. That being the case, it makes no sense to me that we should have duplication of effort when that has a tendency inevitably to undermine the effectiveness of what you're doing. Mr. Simons, I appreciated your acknowledgement a moment ago about how this may be tripping things up. It inevitably does. Let's suppose hypothetically that you were asked for advice on setting up an antitrust regime within another country, within some foreign jurisdiction that didn't already have one. Would you, in any circumstance, recommend that they follow the U.S. model and that they have two separate agencies responsible for civil antitrust enforcement the same way we do here?
No, I wouldn't.
Mr. Delrahim, what's your answer to that same question?
It would be hard to imagine a system being designed at the first instance like we have today in multiple. Now, and as Chairman Simon says, not only do you have two federal agencies, you have, well, I guess I learned recently with the state AGs, 52 states who also enforce the antitrust laws, and all of them, based on a Supreme Court precedent, enforce the exact same federal law that we do, in addition to their state laws. So it's not the best model of efficiency.
Thank you. I see my time's expired. Senator Klobuchar.
Yeah, I just look at this in such a different way. I just see There's investigations going on all over the place. All these AGs have taken it on. And I'd rather have a split investigation than no investigation. And I assume part of the reason that why you've split this is you don't have enough resources individually to take this on yourselves while you're doing your other work. Is that possible?
You know, I think just as sometimes we work with the states, both working together, as many of you know, Microsoft was something that was that began with the Federal Trade Commission. Later, because of a 2-2 tie, the Justice Department took that on. That happens in other matters. So
okay, that's fine. What are you guys investigating exactly with tech?
So I can't talk specifically about individual investigations, but we have a technology task force that we formed in the Bureau of Competition, and they are focused purely on high technology platforms.
And
they're very active. They're anyone who has a complaint about a high tech platform, we are all ears. Please call us.
And can you say the companies you're investigating?
The only one I can say that's publicly disclosed is Facebook, because they disclosed it themselves.
Okay. Do you want to add something?
I think following the same model, the one that has disclosed it is Google, upon whom we have served CIDs. And I'll refer you also to the press statement the Justice Department put out looking at, a broad review, our technology section of the Antitrust Division at the Main Justice, in addition to our San Francisco field office, who has been an expert in this area, are the two that are splitting up the work. We have close to several dozen attorneys who are working on this matter.
And what do you think about the state attorney generals and what they're doing? Do you think that's helpful?
We've had very productive discussions and cooperation. I think at the early stage, we got to make sure that we're not tripping over each other. And so the more coordination there is, the better. We do that with almost every one of our investigations, depending on the states involved. We'll see at the end of the process. I do note the California Attorney General decided not to join the tech investigations. And they have been a significant player with a significant interest in this matter, I would think.
Okay, well, speaking of California, and I think both of you know how focused I am, and I'll get back to this if we have a second round on these tech investigations, because we've been blocked from doing really legislation. That's one of the reasons I've introduced legislation on privacy, political ads, as well as the work that needs to be done in general on antitrust. So that our laws are sophisticated to be able to deal with the current competitive landscape. But speaking of California, so the New York Times is reporting, and maybe other news outlets as well, at 2:28 today, that in fact the Trump administration will end California's authority to set stricter auto emission rules tomorrow. And I would like to know, and this is for you, Mr. Delrahim, are you aware of any contacts between or efforts to exert influence by the President, any employee of the White House, or any advisor to the President and any Justice Department official or employee relating to any investigation into the automakers' negotiations with the state of California regarding vehicle emission standards?
You're referring to the Justice Department's reported investigation?
Yes.
None whatsoever. Nor
Okay.
have I had a communication with anybody outside of our building. There's been reports that somehow we coordinated this with the EPA, DOT, and I would refer folks to the first report of this. Our inquiry and letter to the car companies was sent a couple of weeks before, and the letter from those agencies went the day the news reports publicized our inquiry.
Are you aware of any contacts between officials at the EPA or the DOT and your officials? None from those agencies or from the White House?
I am not. And, I also should say that, the Justice Department often works with different agencies in enforcing their rules. Mm-hmm. So, I don't.
Well, how about other people at the Justice Department, like the Attorney General, or did?
I am not, nor did I communicate with them. And there's a lot of.
Well, why would you be focusing resources on this when we've just discussed all these huge investigations that should be going on 4 automakers that are simply trying to work with one state to figure out what the auto emission standards should be when the administration is so clearly opposed to this?
So that's a very fair question. Let me say why. And this is not unique in this particular instance. We read about the car companies working together in an agreement. There's been multiple Supreme Court cases. Justice Stevens had said that, we have chosen a policy of competition, not collusion. There's nothing wrong with these companies individually to announce, higher emission standards if they wanted to. There may not be anything wrong with them agreeing with the state to do so. In fact, there might be certain immunities like state action doctrine to do so. They cannot cooperate amongst themselves. And I could name at least 4 or 5 other investigations which are similar as far as collusive activity after which we have inquired.
This is in the wake of so many other administration-related comments related to antitrust that I'm just so fearful it is going to undermine our laws, undermine the work of the department. And this gets me to one specific merger, T-Mobile Sprint. Why I disagree with the outcome of that, of course, and why risk the harm to competition when the simple solution would be to block the merger and leave Sprint, a company that is rolling out 5G as we speak, in the market as a competitor?
So we investigated that transaction for about 13 months, and that's not the conclusion we reached. In fact, there was 2 chunks of mid-band spectrum, Sprint holding about, I think, 100 megahertz of 2.5 spectrum, very valuable in this space for 5G, and Dish sitting on 95 megahertz of spectrum for several years, which probably would have been going into litigation next March. What we did is, and then you had 2 major providers in AT&T and Verizon who together had over 75%.
But Dish doesn't even have a mobile network right now, right? They just have the spectrum. They haven't even done this before.
They do not.
It's this hope and a prayer that they're going to build this 5G network.
I don't think it's a hope and a prayer. Our consent decree not only commits them to doing so, they also narrowed the flexible use licenses they had with the FCC. In addition, you're now going to have Sprint T-Mobile combined with the remedies that we put in, providing real competition to AT&T and Verizon for the first time to consumers. On top of that, the 5G that Dish has, now look, they've spent $20 billion on the spectrum and probably committed to spend another $10 to $15 billion in building it. I don't think they're doing that to fail. I hope not, and there's going to be a number of provisions and a monitor in there to do that. So I actually think there's a number of ways looking at it. I think the consumer, particularly in the rural area, is going to win at the end of this if the merger goes forward.
Right. If I don't get a second round here, I just want to thank you, Chairman. I know you've been working on pay for delay and are supportive of the work that we are doing forward. And also thank you, Mr. Delrahim, for your work with us on the Monopoly Deterrence Act and the civil penalties that Senator Grassley and I are working on. Thank you.
Thank you.
Thank you.
Thank you. Senator Grassley.
For the most part, I'm going to deal with some of the pieces of legislation that I'm interested in that affect you folks in your leadership role. So I'll start with Chairman Simon. I introduced the Bipartisan Prescription Pricing for Peoples Act, passed the committee June and now awaits full Senate action. The bill requires the FTC to study the practices of and increasing consolidation among PBMs and other intermediaries in the healthcare marketplace. Probably you wouldn't be aware of studies back in 2005, but some of the FTC's previous studies, however, such as its 2005 analysis of PBMs and mail-order pharmacies, have been criticized for missing the point and not being critical enough of potentially anti-competitive practices. Has the PBM marketplace changed since the FTC's 2005 study, and if so, tell me how?
I think, if anything, it's become more concentrated, and we continue to look at the PBM market, and we're very grateful to you that we were able to provide technical assistance for you on your bill, and we're happy to do the study.
Okay. Then, if our bill, well, I guess you've answered the question. You would carry out Congress's intent and take a hard look at what we're tasking it to do.
Yes.
In that study. Okay.
Yeah, the one thing I would say, though, is we estimate that it would take up 9 FTEs, and so that's another reason we need more funding.
Okay. And I don't mean to be respectful, but you've always been Makan to me. So Makan, the NOPEC bill, the No Oil Producing and Exporting Cartels Act, would explicitly authorize the Justice Department to sue oil-producing cartel members for antitrust violations and clarify that courts shouldn't decline to hear a case based upon sovereign immunity or an act of the state or foreign sovereign compulsion or political question doctrine. I've written to you twice about getting the Antitrust Division's views on OPEC. I haven't gotten any response. What is the Antitrust position on OPEC? Do you support the bill?
Well, Senator, I think as you've stated in your bill, addresses cartels in any way, can harm and do harm American consumers. The legislation and the activities of NOPEC implicate other foreign policy implications, and we don't have an administration-cleared position. You've seen my personal positions on this matter in the past of what we could be doing, and I don't think the current law, current precedents, and the Justice Department's filings in private cases in the past preclude the department from bringing such a case should it decide to bring one against commercial actors involved in OPEC. But as we see some other foreign policy matters, including over the weekend, I think it implicates certain diplomatic relations that other departments of the administration have weighed in on, and I look forward to seeing if we can resolve that and get a views letter to you soon.
Well, you just answered my last question, so I'll get an answer to my letter.
I hope so.
Okay. What do you mean you hope so? You run the show, don't you?
Well, it's the Justice Department, then it goes, and there's an interagency process on this views. But
okay.
I can assure you that it is an area that we've given a lot of time and resources, as has the White House.
Okay. Also, Makan, earlier this year I introduced a bill to provide anti-retaliation protection for antitrust whistleblowers. The bill implements the recommendations of a July 2011 GAO study to increase greater criminal antitrust violation detection and deterrence. Versions of this bill have passed the Senate several times. I hope you're familiar with the bill. If you are, do you believe it would be helpful in going after antitrust violators?
I think it would be helpful, and I believe we have expressed support for that bill. I will check on that and get back to you, but I think it is a sound policy that would complement and further enhance our cartel enforcement activities.
Okay. And then to both of you, I wrote a letter to the FTC last October highlighting potentially anti-competitive contracting practices by hospitals and insurers. The Wall Street Journal reported on a so-called anti-steering contracts that prevent insurers from steering their members to lower cost, higher quality care providers simply because the dominant hospital doesn't want to face competition. Chairman Simon, has the FTC looked into these practices in more detail since my letter last fall? Are they problematic? What actions, if any, has the FTC taken?
We're very interested in looking at unilateral conduct by hospitals that are problematic under the antitrust laws. But generally, when we do that, we find that they're nonprofits and we don't have jurisdiction over them. And so that's another reason why we've been asking the Congress to eliminate our exemption for nonprofits.
Gosh, I never gave that any thought. We ought to consider that.
Yeah, please do.
Okay.
So I can address that as well, since Congress has given us the authority to look into nonprofit hospitals, and perhaps another example of things you probably wouldn't start from the beginning. But we've had 2 enforcement actions on exactly that type of practice, the anti-steering. One involved in North Carolina, Atrium Healthcare, to which we were prepared to litigate. It had been in investigation for over 3 years, and we entered into a consent decree where the hospital system terminated those practices just this past year. And then the second one was in Michigan, a hospital system that had done that. I can also report to you that there is a working group within the administration to look at if there's a regulatory way to address these types of anti-steering provisions, and the White House has expressed a lot of interest in this issue.
Thanks, all of you, and continue to be helpful, please.
Thank you, Senator.
Thank you. Senator Leahy.
Thank you, Mr. Chairman. I know Senator Klobuchar has already raised the questions on the environmental standards in California. Of course, to the average American, it appears to be totally political, especially when the president is going out for a political event in California and will announce that he will set aside a California law as sort of the emperor's here, and let's go with this, and a law that Californians are in favor of because it protects their environment. I mean, the whole thing, if you had it on a TV show doing that, you say, well, that's so ridiculous, so ludicrous. It goes beyond the pale. It has no credibility. But be that as it may, aside from that questionable decision, I do worry about the president using the levers of law enforcement to target political opponents. Earlier this year, it was revealed that President Trump personally demanded the Justice Department block the merger between AT&T and Time Warner, which owns CNN, something in the past such decisions made by the professionals in the Department of Justice. So they then, following what the president said, because he was concerned that news media had actually reported some of the things he had said, they unsuccessfully tried to block the merger in court. Now, it's worrisome because those of us who are lawyers, who've been prosecutors, think of the Justice Department being independent. And I know Justice Department recently refused to turn over documents related to the AT&T Time Warner merger to the House Judiciary Committee. So let me ask you this. As Assistant Attorney General of the Antitrust Division, has the White House, directly or indirectly, ever communicated its preference to you regarding any enforcement or potential investigative action?
I can unequivocally say no, Senator. And in fact, with the AT&T matter, I think it's been public, there were at least 5 different settlements which would have had AT&T buy CNN, and they would have resolved the competition concerns. In addition to the president, there were at least, I think, 14 senators from this body who also wrote to me with concerns about that transaction. I have committed to you in this committee, as well as both in person and in writing, that I don't view politics having a role into our enforcement decisions, nor should it have a role from us abstaining any enforcement decisions.
You say senators have written to you, but nobody from the White House did that. Nobody from the White House, directly or indirectly, indicated their preferences.
That's correct, Senator.
That's your answer?
That is my answer. And in fact, you mentioned the documents not being turned over to House Judiciary Committee. There were many documents that were, that were not privileged for one reason or another, or document that were confidential that were turned over not only to them, but through FOIA requests through multiple parties. And in fact,
during your tenure, has the Antitrust Division ever changed the scope or substance of any investigative, enforcement, or litigation decision based on input from the White House?
no,
None.
none.
I ask you this because there is this appearance that the president has successfully influenced specific enforcement decisions. And the day after T-Mobile, for example, announced its intended merger with Sprint, senior executives of T-Mobile began booking rooms at a hotel the president owns here in Washington, D.C. While lobbying the Trump administration to approve the merger, they spent some money at that hotel, $200,000. Must have been a nice room. Were you or any other Justice Department officials made aware of T-Mobile executive's decision to stay at the Trump Hotel before that information was reported publicly?
No, Senator, I was not.
Did the White House express its preferences with regards to the T-Mobile merger to DOJ?
Not that I'm aware of. Not to me, certainly, and nobody that I know of in the division.
Well, if they had, you would have been aware of it, correct?
I would have been.
Just coincidence that T-Mobile repeatedly returned to the Trump Hotel, running up that tab while seeking the Justice Department's approval for its merger?
I would direct you to the T-Mobile executives of why they did. I could give you one reason they might have. That the Trump Hotel is right next door to the Justice Department building. So I think as a matter of convenience, it might have been, but I have no idea.
So is the Marriott, the Willard, and several others.
It's literally next door, Senator, at the Justice Department. So I have no idea why they did, nor does that factor into my decision.
I've actually been to the Justice Department. I've been in that area. I know where it is. And I know that it's very important to them. They be able to have somewhere they can walk to in a matter of seconds, because none of them have cars available to them or anything else.
Senator, I can assure you that my decisions were not based on the hotel stays of any merging parties. I can tell you that. My enforcement decision is not bought by a couple $100,000 of hotel stays.
Did you commit to comply with the notice of reporting requirements provided in the Music Modernization Act before you took any action in DOJ's review of the ASCAP and BMI consent decrees?
We have, Senator, those are important decrees. We have complied with the provision of the Music Modernization Act, which states that we should, within reasonable notice, notify the committee should we decide to terminate. We've done even more than that. Before we published this for public comment, we notified the ranking member, chair of the subcommittee, as well as the full committee here and in the House. Before we decided to do anything, we have communicated that. I'm no stranger to this committee, having had the great privilege of serving on the staff of the committee, so I know full well the importance.
I had the opportunity to be on this committee at the same time you were here.
I had the great honor to serving alongside of you, Senator, both as chairman and ranking member.
Well, I will submit some other questions, if I might, for the record, and for both Mr. Simons and for you, sir, and ask that you respond to them.
Thank you.
Senator Hawley.
Thank you, Mr. Chairman. Just as we start, I hear a point about something not before us here today. Amazon, as I'm sure many of you have seen, the Wall Street Journal has recently reported that Amazon has potentially changed its algorithms in order to favor its own products rather than to actually report what consumers are looking for. I've raised concerns about this publicly. Amazon responded to me this morning and said there's absolutely no truth to any of those reports. So, Mr. Chairman, I've invited them to come to this committee. I'm sure you'd be happy to have them. And Amazon, you can come here to this room. You can sit at that table. You can take an oath. And you can answer our questions. And you can open up your books so that we can all see. And we invite you to do so. We'd love to, I'm sure, love to have you here. So we look forward to Amazon's response. I'm sure they have nothing to hide. Gentlemen, thank you for being here. I have to tell you, just to put my cards on the table, I'm concerned about the state of antitrust enforcement. As somebody who believes in competition, who believes in free and open markets, and thinks that competition actually is good for American individuals, American families, and American consumers, I'm concerned about what I see as a pattern of lack of enforcement, pro-competition enforcement. And I understand that both of you say that your respective agencies need more resources. Until we can figure out some of these structural problems that you both alluded to, I don't know why we would spend more money to do things that frankly aren't getting results. Chairman Simons, let me just begin with you. I want to ask you about the FTC's recent settlement with Facebook, company you now say you're continuing to investigate. That settlement was $5 billion. Is that right?
Correct.
Now, Facebook's revenue last year, I believe, was $56 billion, so the fine was worth less than 9% of Facebook's revenue. Is that right? Am I getting those figures right? Did you interview Mark Zuckerberg during your investigation?
No.
Did you interview Sheryl Sandberg during the investigation?
No, but we had their email.
Did you ask to interview them? Either of them? Did you interview other major executives?
I believe so.
Who?
I don't have a list. I could get it for you.
You can get it for me. Great. I'd love to see it.
I think it would have to be pursuant to a non-public
I'd be happy to get any information I can get out of the FTC. So we'll take it in whatever format that you're able to give it to us. Let's talk about Google for just a second.
So can I say something about Facebook?
Go ahead.
Yeah, so Facebook was a situation in which we were faced with either taking the settlement that you described, which was $5 billion, and a huge, very, very significant injunctive relief as well, and comparing that to what we could have gotten in court. And if we had gone to court, we would have spent years litigating, and if we had won at the end of that, we would have come up with something that was far less. The court, we have to go to court, and a court would have to award what we were looking for, and a court would have given us far less, both in terms of the civil penalty, the $5 billion, and also in terms of the injunctive relief. So
well, I'm interested you say that because I noticed that your agency it doesn't take a lot of cases to trial. In fact, you don't usually go through the adjudication process on very many cases. Isn't that right?
We have a lot of litigation. We have a lot of litigation on the competition.
You
side.
settle most everything, don't you?
Well, that's true of every enforcer.
So that's a yes, though. I mean, here's my question. What I see from your agency is frankly a culture of paralysis. I'm tempted to call it a culture of capitulation, and I worry about agency capture. I just wonder, is there something, I don't have the answer, but is there something structurally problematic at the FTC? I mean, what is it that the FTC is really doing with its time? I mean, I think it's fair to ask, and I don't know the answers to these questions, but I think that it's time that we ask them. I don't know why we would authorize more personnel and more money for an agency that doesn't seem to be vigorously enforcing the laws. Now, you both have talked about the overlap in jurisdiction. Maybe we should clean up that overlap in jurisdiction by removing it from one of your agencies. I mean, what do you think about that? Would that be something that would make the process better? Mr. Delrahim, let me ask you to give you the chance to weigh in here. I mean, should we clearly designate enforcement authority to one agency so that we don't have these clearance problems and this seeming lack of enforcement we've been seeing?
Well, as an administration official, I don't have a view on that, but I think it's perfectly an appropriate area of inquiry for this committee to take a look at the overall system that we have in this country. I mean, I was privileged to serve as a commissioner on the Antitrust Modernization Commission. There were a number of recommendations in that 10 years ago, or 12 years ago now, that were there. But that was one of the very small areas that we looked at. But there's a number of areas of inquiry that I think are worthy of your attention.
We're reading now in the press about these fights, these interagency fights. Chairman alluded to them earlier. I'm concerned that these turf wars are leading to a lack of enforcement. I mean, that you're not able to actually get after the business that you should be getting after, doing the job you should be doing. And again, maybe it's time for this Congress to do something about it. Let's come back to something else I wanted to ask you about, Chairman Simon. I read somewhere that 2/3 of FTC commissioners and bureau directors go on to work for or represent the tech giants. That can't be right? Is that right?
That's not a statistic that I've seen.
Would you, if that's accurate, would that concern you? I mean, why would that be the case? Why would that be happening?
Well, my sense is that the people, like, so for myself, for example, so I represented people who were against the big tech companies. So I represented a bunch of companies who were trying to challenge Microsoft back in the late 1990s. So it could be on either side of the spectrum. So I don't think it's necessarily one way or the other.
Well, here's at the end of the day, I think that we're seeing structural issues play out in the press. We're seeing a troubling lack of enforcement, whether it's Facebook, whether it's Google. I think of the fact that we know from a leaked FTC memo report that Google had an internal policy, this is a quote, to bias ourselves. That's Google talking in their own algorithm. The FTC, I think, had this report as early as 2012, yet didn't take any action. Meanwhile, the EU fined Google $2.7 billion. So I don't know what the answer is here, but I think that it's pretty clear we have a problem, and it's pretty clear from what we're reading in the press about the relationship between your entities that we have a problem. And I think it's time, Mr. Chairman, that we addressed ourselves to solving it. Thanks so much.
Can I say one thing about that? Just one thing. I'll just repeat my former boss, Attorney General Ashcroft, is that sometimes, as the Chairman said, I think 98% of the work and cooperation between the two agencies work well. But as General Ashcroft used to say, the press reports about the plane crashes, not the thousands of safe landings every day.
Yeah, I agree with that.
Reminds me of the story my late father, who was an attorney, used to tell, where he would say, when people attack lawyers, it's a shame when you sully the dignity of a profession on the basis of only 800,000 or 900,000 bad apples. Senator Blumenthal.
I'm sure he didn't mean anything personal by it, Mr. Chairman. But just to quote another senator, it's pretty clear we have a problem. It's pretty clear we have a problem, if only it's a perception problem. And Mr. Simons, I take your point about litigation taking a long time. I was a state attorney general for 20 years, and I helped to lead the Microsoft case. And by the way, just so you understand, that's an example of states enforcing federal antitrust law and doing it successfully, adding an additional dimension in partnership with the federal government. So this idea that two sovereigns shouldn't be enforcing the same laws or their own laws, I think, fails to take account of the great genius of our system, which is we have state enforcers, and they protect consumers. And by the way, that $5 billion fine, it raised the price of Facebook stock the next day, and it increased the net worth of those executives. But I take issue not so much with the size of the fine, the lack of structural change. And you found in the course of your privacy investigation that, in fact, the company used its control over user data to sell advertising. That has antitrust implications, does it not, Mr. Simons?
It's possible it could.
Well, it's more than possible. It's what you should be investigating. Yesterday, I
can't talk about the details of what we're investigating with the Facebook antitrust investigation, but we are investigating for antitrust violations.
I'm telling you, you should be investigating it.
Yes.
And by the way, the fact that you're coming here without any specifics, I think, reinforces the impression that federal antitrust enforcement is an empty suit. Call it a culture of capitulation. What the public sees is a facade with respect to big tech and no immediate prospect of urgency or active enforcement. And I might just add, in addition to the report yesterday about Amazon changing its search algorithm to promote its own products, there's also a report recently in the New York Times that Apple operates its Apple Store and App Store to offer apps that may be tipping the scales in favor of its own products. Google using its search engines to promote its monopoly and its own self-aggrandizement. what we see here is a common theme in big tech, that dominant market share is used to cement monopoly and push competitors out of the market. That's fair to say, isn't it?
Yeah, we have the same concerns you have, and that's why we formed the Technology Task Force to focus on exactly these issues.
But what I'm saying to you is we need more than a task force. We need action. The big tech companies are not waiting for you to finish your cases. Facebook has acquired more than 70 companies over the past decade and a half. They are moving forward. They are cementing Instagram and WhatsApp. They are structuring their companies so that you can't unscramble the egg. And that's why we pulled the trigger on Microsoft when we did, and brought a lawsuit that we were prepared to try, and we did try. So I'm suggesting to you that the same urgency has to be brought to bear on big tech, and
We share your urgency, Senator.
Well, I hope you evidence it in action.
We're
not
working
just
on it.
Words. Let me ask, because my time is limited, to move to another topic on the issue of the Ticketmaster Live Nation consent decree. Is the Department of Justice considering extending the merger conditions?
Senator, that's the consent decree expires next year. We have been examining allegations of violations. Beyond that, I can't comment about what we are finding or intend to do. But rest assured, it's one that we heard you loud and clear in your letter, as well as several folks. One of the challenges that I fixed when I arrived is that all of our consent decrees going forward, since I've been confirmed, include provisions that forces the parties to agree to a lower standard for review. The organic standard for a violation of a consent decree, which is probably why we haven't seen enforcement of consent decrees, too many of them, was that a term has to be clearly unambiguous, and you have to prove it in a court by clear and convincing standard. I don't need to tell you how difficult of a standard that is.
That is a difficult standard, I would agree,
and that's the standard we're living with.
I hope you would agree with me that the merger conditions have been largely ineffective, and there's a need for scrutiny and further review here.
Absolutely.
Let me also ask you about group purchasing organizations. As you know, GPOs were designed to keep costs down, but recent research has concluded that, in fact, they were a contributing factor to rising hospital costs, medication shortages, and stifling introduction of innovative products from smaller companies. What is the FTC doing to address behaviors like exclusionary and sole source contracting in GPOs and the medical device industry?
So I can't talk specifically about any non-public investigation, but these are things that we look at very regularly. I mean, yes.
Are you looking at them now?
I'd have to check and get back to you.
I would appreciate your getting back. Let me just suggest that if you care about health care costs, and every single member on a bipartisan basis of this body cares about health care costs, every single American cares about health care costs, you would answer, yes, we are looking at it actively and aggressively because GPOs potentially contribute to the rising health care costs of our country. So I'd appreciate your getting back to me.
Yes,
Senator, on that point, if I could, at the risk of interfering,
absolutely,
is that some of the competition issues raised in that industry is due to Congress in 1997 provided an exemption from the Medicare anti-kickback statute. And that exemption has been kicked in, and it's a mile long, and it has created a situation where some of these GPOs are buying exclusivity at the risk of innovation, at the risk of cost, and the risk of lives of patients.
I have one more question, and it concerns the automobile industry, the investigation that has been discussed. To quote the former chief counsel to the DOJ Antitrust Division, Gene Kimmelman, I'm sure you both know him, he has said, quote, "It has never been considered a violation of antitrust law for companies to get together and promote a policy decision. Now, I'm stating an axiom of antitrust law, well known to both of you, that if manufacturers or retailers or anybody else get together to talk about a policy position, it is not a violation of the antitrust law. How do you justify this investigation?
I'll take that one step further. It's not even a violation of antitrust law should they go to an agency and seek regulation or legislation. The Supreme Court has said the antitrust laws don't trump the right to petition your government under the First Amendment.
Right.
However, it's been a clearly violation when there's collusive activity. In fact, there was a case in Michigan where auto dealers had agreed amongst themselves not to open on Sunday so they can observe church hours. The courts found that to be a violation. Attorneys agreed amongst themselves to increase the standard of representing indigent defendants, a goal that we all support.
They're simply agreeing they're going to follow existing state law.
So we don't know. All I know is what was reported in there. That's not what they have said, and they don't need to agree amongst themselves to do so. They could tomorrow disband the agreement and say, you know what, I'm going to agree to higher emission standards. We don't have a problem with that. We would encourage that. I don't know why they need to agree amongst themselves to lower output. There's been an established policy to not do that, and a policy towards competition rather than collusion, regardless of the outcome. We've seen that in Maricopa County, where the physicians got together to set a max price for health care. Something we all support is lowering health care. Supreme Court said, no, that's illegal. You don't do it collusively. So
well,
that's
I hate to we could have a longer discussion, but I appreciate the chairman permitting me to ask that question.
You bet. Happy to do it. We've got a vote. The clock is ticking down on the vote. We rely on the good mercy of the cloakroom staffs. But Senator Whitehouse, I understand you'd rather go first rather than after we recess and reconvene.
If you don't mind, I'll follow up on Senator Blumenthal's questions because, Mr. Delrahim, in every single example you just gave, it was collusive conduct by the group without the participation of a government, right? What was your first example?
To be honest,
the lawyers getting together.
The lawyers got together. It probably did not include the bar system, but there have been many examples of this, including the North Carolina Dental Board, where the parties have done that. So it's not so much that just the government being involved in a collusive conduct does not immunize that. The Supreme Court has been quite clear. You need to meet two prongs. There has to be a clearly articulated policy by the state. There also
That's
has
for
to
state
be
action. That's different. This is like North Pennington getting together, redress grievances. How on earth is it possible that these four companies, which have a very small share of the overall car market, sitting down with California in these circumstances and negotiating their fuel standard with California is a violation, and what the American Petroleum Institute does in this building every day, plotting and planning to try to defeat renewable energy, clean energy, electric vehicles, all of those groups, the entire fossil fuel industry, out to try to damage its competitor. All day long they do this here. The Koch Industries people defending their ability to refine and pollute with fossil fuel. Marathon Oil has fingerprints all over the whole auto cafe standards debacle. It's just bizarre that of all the different political schemes that are going on right now to harm competition, the one that you pick out is the one in which the White House has gotten itself enraged because its scheme on behalf of the oil industry to bust up the cafe standards got disrupted by the auto industry going to a different government and agreeing to a different rule.
If I may answer you, 2 points that you've raised. First, it's not the one I've picked out. We have looked at the college admission counselors. We have looked at APs in elite high schools. We have looked
college
at
admission counselors were going to a state and asking for permission to do a certain thing or asking for a certain regulation, and you went after that as an antitrust violation?
No, Senator. The college.
Well, you're
Let me ask
quit throwing apples when we're talking about oranges.
Well, the conduct needs to be examined first, then the immunity to that type of conduct.
Are you looking at the American Petroleum Institute? Have you looked at the fossil fuel industry's effort to combine and collude to manipulate Congress to squelch competition? That's perhaps the most obvious fact of our existence.
I hear your point, Senator. Let me just tell you, we have not concluded that it's a violation. All I have done so far is ask them to come in and explain to us if there was communication between them, the context of which and why they need to do that collusively.
You don't think that the members of the American Petroleum Institute discuss with each other what they're going to ask their lobbying organization to do?
If they discuss,
you don't think the American Chemistry Council does that?
If they discuss prices and output, you would be sure I'd go down on them and send them a letter. Do you have any evidence? There's been no reports that they have done that, Senator.
Fuel
Nor have I
standards
gone
are
against
prices?
these folks.
Fuel standards are prices?
They have come to Congress, as far as I know, and just like you said, that is protected under the First Amendment. I'm not defending them, and I would defend their rights, these 4 car companies, if that is what they did. But that is not what has happened. So if you're telling me I can't even investigate 4 companies that might have colluded, we don't even know if they've agreed on prices. We don't know if they have said, look,
you don't know if they've agreed on prices? Do you have any information that they've agreed on prices?
I have nothing. That's the purpose of an investigation. Doesn't mean I'm bringing a lawsuit.
Have you ever heard of
tomorrow.
predication? You just fire off letters at random without any evidence that the misconduct is underway?
You fire off letters to asking them for information to see what the next steps is. I don't know if you've read the letter that I've sent. I brought it here. Apparently some in the media have it, but I'm going to read it for you because I think that should alleviate a lot of your concern.
Doubt it, but go ahead.
I'm somebody who's owned 2 Priuses and one of the first owners of Tesla. I'm not out there, and I lived in California, believe me. I'm not out there to try to, increase pollution into the air, but I have a duty to do, and I'm not going to shirk that for political heat.
I think antitrust division the opposite is my suggestion to you. That you're doing this for political reasons, that you're doing this because the administration is fed up and cross that they got their little scheme to bust up the cafe standards
that went out,
interrupted by California.
With respect, Senator, I think once you hear the exact letter,
put it into the record.
Do that.
Put it into the record. My time is up. What I would like to ask you to do, though, as a question for the record, is to ask for, let's say, a year's worth of such letters that you've sent to other industries. Again, this seems really unique. I mean, I've been the Attorney General of my state. I've done antitrust work. Yes. It was always the gold standard that when a group of companies got together with a government to negotiate what the government standard would be and their adherence to it, that was protected. So to me, this rings all sorts of really strange bells. It's really bizarre. And in the context of the long saga from the voluntary agreement with the Obama administration to the discomfort with some of the technical terms to reopening the conversation to suddenly Marathon Oil and other companies barging in and running off with the conversation, forcing the auto industries to find a fair forum someplace to try to work this out, the fair forum being the state of California, a government. And now suddenly, with the president evidently furious about having this whole scheme disrupted, suddenly this very peculiar letter that doesn't seem to have either basis in Norr Pennington or a rationale in predication from you, it looks an awful lot like scores are being settled here. And God forbid that the Department of Justice should ever become the tool for political scores to be settled.
I agree with you on that, Senator, and that's not what's going on here.
We'll see.
Mr. Chairman, I just follow up quickly, not a question, but I've sent letters with Senator Grassley about the oil company's conduct, Senator Whitehouse, when it comes to trying to push out anti-competitive moves for biofuels and how they've worked with gas stations and what they've done to try to limit the marketing of biofuels. And so I'd be happy to send those to you because I don't know that we've gotten much response when it comes to that.
We stand recessed, subject to the call of the chair. My best estimate is that we'll be gone about 45 minutes. We'll make it back faster if we can. Thank you.